afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society. I'm delighted to welcome you to our virtual program and platform for today's program with Professor Jack Goldsmith for the launch of the Society's 2025 lecture series entitled The Lives of Plaintiffs Post-Court Rulings. Our speaker today has shown great patience with us as we originally discussed this program with him in 2020, just after his book was published and just before the pandemic. And we're delighted that he endured and is with us today. Jack Goldsmith is the Learned Hand Professor of Law at Harvard University, a non-resident senior fellow at the American Enterprise Institute, and co-founder of Lawfare. He is the author of In Hoffa's Shadow, Stepfather, A Disappearance in Detroit, and My Search for the Truth, which is the inspiration for today's talk. He's also written on topics related to presidential power, terrorism, national security, international law, and internet law. He holds a JD from Yale Law School, a BA and an MA from Oxford University, and a BA from Washington and Lee University. He clerked for Supreme Court Justice Anthony Kennedy and the Court of Appeals Judge Harvie Wilkinson and Judge George Aldrich of the Iran-U.S. Claims Tribunal. Before teaching at Harvard, Jack served as Special Counsel to the General Counsel of the Department of Defense from September 2002 through June 2003, and then as Assistant Attorney General, the Office of Legal Counsel from October 2003 through July 2004. Excuse me, as one would expect from such a resume, Jack has had and is having an outstanding career. But to me, while his professional resume is impressive, certainly, there are several other elements of his experience that are even more remarkable. He was given the opportunity to develop an expertise in surveillance and national security issues at a young stage in his career, and he did so with typical energy. Upon doing so, he had the courage and humility to reverse a course in his life and repair his relationship with his stepfather, Chuckie O'Brien, the subject of today's lecture. This enabled him to apply his legal expertise in a unique way to, in his own words, the greatest mystery in American history. And that mystery was one in which Chuckie O'Brien played an unfortunate, and as we learn, an unfair role that unfolded during Jack's tender years, beginning at the age of 12, when their father and son relationship began. And not only did Jack devote enormous energy and expertise to try to get to the truth of that mystery in Chuckie's defense, but he's also written a brilliant, compelling, and easily readable account of it to shed more light on that perplexing time and events in our history. The Supreme Court played an interesting and perhaps peripheral role in the events surrounding Chuckie O'Brien's involvement in that mystery, and we're about to hear all about it. We will take questions from the audience when Jack concludes his lecture. So please share your questions in the Q&A box at the bottom of your Zoom screen. Thank you for being with us today, Jack, and the floor is yours.
Thank you, Jim. I'm going to try to, for that kind introduction, I'm going to try to share my screen so that I can use slides. Okay, is that showing the slides?
It is. Great. Thank you.
Great. So thanks, Jim, for that kind introduction. Thank you all for coming today. I'm going to talk, this talk is at bottom about a Supreme Court case that in the 1960s was of medium significance. It's kind of forgotten today, O'Brien versus United States. And I'm going to explain, a part of what I'm going to talk about is personal because I had a connection to that case, as I'm about to explain. Some of it has to do with the Jimmy Hoffa's disappearance. All of this, as Jim said, grows out of a book I wrote 6 years ago called In Hoffa's Shadow. So I'm going to talk about the Hoffa disappearance in passing. I'm going to talk about my life a little bit in passing, but I'm going to try to focus on some important but forgotten periods in the history of surveillance law that are really revealing and enlightening in the 1960s. And that's going to be the thrust of my talk. I'm going to begin with my time at the Justice Department. As Jim said, I was the Assistant Attorney General for the Office of Legal Counsel from 2003 to 2004. This is the branch of the Justice Department that makes rulings on legal issues for the executive branch, exercising the delegated power from the president. And it's a very consequential position. I was very grateful and honored to have this position. One of the things that I encountered when I was there, I was only there for 10 months. That's another story and another book. But one of the things I encountered there was a very highly classified program called, which came to be called as this Inspector General report on the right here, which is declassified now. I never thought I'd be able to talk about this. Came to be called the President's Surveillance Program. And to make a long story short, this was a program of warrantless content and metadata collection in connection with the post 9/11 war on terrorism. And when I came into the government, I had the responsibility for there was a responsibility for the head of OLC to determine the legality of the program and to ensure its legality every 6 or 8 weeks. And in the course of doing that, I discovered what I believed were some very, very serious problems with the program and with the legal basis for the program. And I'm not going to talk about that now. I'm happy to answer questions about that at the end if you want. But it was in the context of trying to figure out this program that I was reading about the history of the Fourth Amendment. And because I was a national security scholar at the University of Chicago when I came to the government, and I knew about the Fourth Amendment, but I wasn't expert on it. So in the context of trying to understand the President's surveillance program and its legality, I was kind of doing a crash course in the history of the Fourth Amendment and surveillance law. And in that context, one night in the Justice Department in my office, I was reading a case called Berger versus New York. And for those of you who know, this was a somewhat famous decision that in which the court said started to impose constraints and requirements, more robust requirements on the government's ability to use electronic eavesdropping, both wiretapping and bugs. And I was reading this opinion late one night, and as I was reading the opinion, I came across these two citations: O'Brien versus United States and Hoffa versus United States. And my eyes opened when I saw that. I said, wow, O'Brien and Hoffa, I think I know what those might be about. And I did know what they were about. And so let me just tell you a bit about who O'Brien was and who Hoffa was. I'm sure that many of you have heard of Jimmy Hoffa. He was the most consequential labor leader in the country, head of the Teamsters in the 1950s and 1960s. He had connections to the mob. He was a very successful labor organizer, massively popular with the rank and file, and massively successful in helping them raise wages and benefits. And Chuckie O'Brien, who is here in this picture during one of Hoffa's trials, this one in Nashville in 1962. This is Chuckie, as he often was, a few steps behind Hoffa. Chuckie O'Brien met Jimmy Hoffa when he was 5 years old, and he was basically more or less raised by Jimmy Hoffa. He considered Hoffa his father, basically his father figure, if not father, because Chuckie's father left and then died when he was a young man. He revered Hoffa. When he became 18, he basically started working for Hoffa. He basically became Hoffa's right-hand man. He was always at his side in the 50s and 1960s and early 1970s. Victor Riesel, the labor journalist, described Chuckie as Hoffa's, quote, intimate companion, driver, bodyguard, and special troubleshooter. That's kind of a nice way of putting it. He was also Hoffa's go-between with the mob because Chucky's mother was had close relationships with the mob, and Chucky was very close with some important figures in Italian organized crime. And so Chucky was a go-between between Hoffa and the mob. Chucky was so close to Hoffa that many people thought that he was Hoffa's illegitimate son. Mario Puzo modeled Tom Hagen. This is the Irish orphan who was the consigliere for Don Corleone. He modeled him on Chucky, and he didn't know Chucky, but in the popular press, Chucky was this close confidant to Hoffa, and Puzo describes it as follows. Tom is a sort of a rough model on a guy called O'Brien in Detroit, who was like a son to Jimmy Hoffa. So Chucky and Hoffa, it's impossible to describe how close they were in the 50s and 60s and early 70s. When Hoffa went to jail, Chucky took care of his wife, and basically he grew up in the Hoffa household. But Chucky and Hoffa had a falling out. Jimmy Hoffa, as you might know, famously disappeared from a parking lot out in the Detroit suburbs on August 1st, 1975. The mystery still hasn't been solved. He and Chucky had a falling out a few months earlier, and soon after the disappearance, Chucky became a central suspect. He became a central suspect because he was very close to the mobsters who were thought to have been involved in Hoffa's disappearance. There was also blood found in a car from one of the leading suspect's sons that Chucky was driving on the day of the disappearance. And this is the headline from that. There's a lot of circumstantial evidence that was pointing to Chucky at the time. I'm not going to get into that now. I hope if you have questions about it, I'd be happy to answer. This is a picture of Chucky showing up at the Hoffa grand jury in August of 1975, where he took the Fifth Amendment. So when I read in OLC these two cases, I knew about this history. And the reason I knew about the history is because Chucky was my stepfather. And here I am, that's me in the uniform. I was at a military academy, and that's me next to Chucky in the white shirt. This is in my teens. My mother married Chucky 6 weeks before Hoffa disappeared. And it's hard for me to exaggerate what an important influence Chucky had in my life in my teenage years, especially. I'd never had a father. My father left my mom when I was young. And Chucky was just an extraordinary father. He wasn't educated. He was not an educated man, but he was a great person and a great father. He gave me love, masses of security. He himself always had trouble with the law and always had trouble distinguishing right from wrong, but he sure, in the same paradoxical way that Jimmy Hoffa was a moralist, even though he was evading law and morals on the side, Chucky instilled serious, he was responsible for me not drinking, not doing drugs, and really being a straight arrow in my teenage years. But the most important thing is he gave me love and security in a way that I never had from a man, and I was just enormously, enormously close to him. Now, I have to say, it was an odd time because Chucky was in the Teamsters Union. He was the leading suspect in the Hoffa disappearance. He was always being hounded by the FBI, and he was very close with the mob. And here are two of his closest companions in the mob who were known to me as Uncle Tony Provenzano and Uncle Tony Giacalone. Provenzano here is at his Hollandale, Florida house where I often used to visit just after the Hoffa disappearance, explaining he didn't know what happened. And this is Uncle Tony when when he was arrested on a tax evasion charge. These two men were, I would later learn, violent mobsters. But when I knew them, they were upstanding gentlemen whom I respected and actually thought the world of. I loved them, and they loved me, and I was very close to them. So this was my world as I was growing up as a teenager. This is a picture from college graduation from Washington and Lee in 1984, and I'm going to make a long story short here. But I started to break from Chucky when I was in college. My name was Jack O'Brien from the age of 12 till 21. When I got to college, started to think about ambitions for law school. I had been accepted to Yale Law School by the time this picture was taken. I started to think it might not be so great for my legal career to have mob ties and to be associated with a leading suspect in Hoffa's disappearance. The things I used to admire Chucky for, I used to not admire. I was reading Hoffa books that revealed to me that my uncles Tony weren't such nice guys and that Chucky had a violent past and may indeed have been involved in the Hoffa disappearance. And so, to make a very, very long story short, I broke with Chucky about this time. I changed my name back to Jack Goldsmith, the name I was born with. And basically, making a long story short, I didn't talk to Chucky for the next 20, 25 years. And I basically cut him out of my life. And I convinced myself that I was virtuous and I was on the path of the law and justice, and he was the opposite, and that I just needed to go my own way. And I'm being a little harsh on myself. That may sound a little harsh on myself, but that in a nutshell is what happened. So that's the background. And then 20 years later, I'm at the Justice Department, and I'm reading about this government surveillance program that, to my mind, is unlawful and is happening in secret. And Chucky had always told me about how the government, about how Bobby Kennedy had broken the law and illegally surveilled, and Hoover, and illegally surveilled Hoffa and him. Chucky had also told me he had won a famous Supreme Court victory. I frankly didn't believe any of this. I didn't believe anything that Chucky had said about Bobby Kennedy or Hoover or a famous Supreme Court case. I thought he was, as he often did, and forgive the phrase, and he used to use this phrase, bullshitting me. And yet here I was in the Justice Department, age 41, in the Robert Kennedy Justice Department, and where, that's the name of the building, where I was involved in a program that was basically very much the kind of thing that illegal surveillance in the government in secret that Chucky had said was going on against him. And I just read this opinion, O'Brien versus the United States, which I'm about to tell you the backstory of, that basically showed me that Chucky was right. He was right about what he had said about the government in the 50s and 60s and illegal surveillance. He was right about what he said about the government being able to break the law in secret and surveil people illegally and not get caught. And that's the story, the backstory I'm going to tell you about. This is known but not terribly well known, a known but not terribly well known element of the history of surveillance law in the Supreme Court and in the United States. So this is the backstory, basically. I'm now going to go back to the 1930s and tell you the story of how we got to O'Brien versus United States. And it's really a remarkable story with a lot of remarkable figures in American history, starting with J. Edgar Hoover. Let me just see something here. Give me 1 second. So Hoover joined the Justice Department in 1917. He became the director of what was the precursor to the FBI. It was called the Bureau of Investigation, I think in 1924. And he kept that role when it became the Federal Bureau of Investigation. He became the director of that. He kept that role until 1972. He was basically in the department for 55 years and led the equivalent of the FBI for, I think, 49 years. And the surveillance story I'm about to tell you about, here's Hoover through 4 presidencies. That's picture of him during the 30s under FDR. There he is with Ike. There he is with the Kennedy brothers. And there he is with LBJ. And, Hoover's story is well known. I'm not going to talk too much about it, But Hoover was the driving force behind the illegal surveillance program that was going on inside the government all of these years. And I'm going to start with a case called Nardone versus United States. This was decided in 1939. I'm going to be very simplistic in general in describing these cases. I'm going to talk about them at the highest level of generality and not get into the legal weeds. But basically, this case in 1939 ruled that the Communications Act, I think of 1934, applied to the government and prohibited the government from using wiretaps as evidence in criminal trials. And Robert Jackson, who was later, of course, on the Supreme Court, was the Attorney General at the time. And Jackson read the Nardone opinion not just in light of the statute that the Supreme Court was interpreting, not just to prohibit government wiretapping and using the information in trial, but to prohibit all wiretapping. That was Jackson's interpretation of the statute as interpreted by the Supreme Court. And so Jackson decided in the spring of 1940 to ban government wiretapping. No government wiretapping would be allowed. And this headline says it's on Hoover's recommendation, but believe me, that was not the case, as I'm about to explain. Hoover did not like this recommendation. For those of you who don't know, the Federal Bureau of Investigation is a component of the Justice Department. So technically, the Attorney General is over the director of the FBI, although the FBI director obviously has enormous independence. So this is what the world was told, that the Justice Department, in light of that Supreme Court case, had banned wiretapping. But the truth was somewhat different. This is a memorandum a few months later from President Roosevelt to Attorney General Jackson. Hoover, this was at the run-up, of course, to World War II. Roosevelt was deeply worried about spies and saboteurs inside the United States, and so was Hoover. And Hoover told FDR, if we ban wiretapping, we're not going to be able to find the spies. And so the President of the United States, exercising his ultimate authority to interpret law for the executive branch, sent Attorney General Jackson a memorandum that basically said, I'll actually read this. These are Roosevelt's words, and he wrote this himself. Roosevelt, who went to law school, was a lawyer. He had a C- average at Columbia, but he did understand the law. I am convinced that the Supreme Court never intended any dictum, he's talking about the Nardone case, to apply to grave matters involving the defense of the nation. And then there's some more analysis, and he says to Jackson, you are therefore authorized and directed in such cases as you may approve after investigation of the need in each case to authorize the necessary investigating agents that they are at liberty to secure information by listening devices directed to the conversation or communications of persons suspected of subversive activities against the government of the United States, including spies. One way of putting this, not to put too fine a point on it, the president overruled the Attorney General with regard to spies and saboteurs on grounds of national security and secretly told him that he could continue to use secret listening devices in that context, despite the Nardone opinion and despite the headline in the New York Times and the government's announcement to the world. So this is the beginning of a pattern. This is the beginning of a pattern where the Supreme Court is saying one thing about the legality of electronic surveillance, and the government in secret is doing something different. The next stage comes in a case called Irvine versus California, decided in 1954. The Nardone case and the Roosevelt memorandum concerned wiretaps, tapping wires on telephones. The second form of surveillance was bugs, placing a microphone inside someone's residence or office or something like that, usually through trespass, i.e. breaking and entering, doing a black bag job, so to speak, putting the bug inside the house. And the Supreme Court in 1954 said, in an opinion written by Justice Jackson, who was now on the court, no longer Attorney General, declared what many had thought to be the case in any event, that this practice of breaking into homes to place a microphone and listen in was illegal. Justice Jackson said that officers of the law would break and enter a home, secrete such a device, even in a bedroom, and listen to the conversation of the occupants for over a month would be almost incredible if it were not admitted. Few police measures have come to our attention that more flagrantly, deliberately, and persistently violated the fundamental principle declared by the Fourth Amendment as a restriction on the federal government. So that's what the court said in 1954. Meanwhile, over in the Justice Department, they were finding ways to get around this. And Hoover basically made the same pitch to Ike's Attorney General Brownell that he made to Roosevelt in the 1940, that we needed to find a way around this for certain subversives. So despite Irvine, Brownell authorizes in a secret memorandum, that Hoover could continue to bug with trespass, i.e. to break in, against espionage agents, possible saboteurs, and subversive persons. And he reasoned that the considerations of internal security and the national safety are paramount, and therefore may compel the unrestricted use of this technique in the national interest. And the justification here is that there's something special about national security. The president has Article II power, and that we can continue to do this for national security reasons. So that was an extension of this authority in secret in 1954. And then the next extension came with regard to the mob in July 1959. In 1950, Hoover had always avoided asserting jurisdiction over the mafia, at least until 1957, when in this famous meeting of mobsters that went bad up in upstate New York, there was a national meeting of the Italian syndicate, and it was stumbled upon by local cops and basically broken up. And the bottom line from this event was that it could no longer be denied as it was. There just wasn't clear how big of a force, how real of a force the Italian syndicate was. But after Appalachian in 1957, it became clear that it was a very serious organization committed to organized crime. At this point, Hoover decides he needs to go after the mob, and his main tool in going after the mob was a bug. But he needed to find a justification for using the bug, because this is no longer a national security justification. These are domestic criminals. And so in 1959, picking up on a word in the earlier memo that Brownell had sent, Hoover construed the earlier memo, which involved subversives from abroad and threats to national security, as an authorization to plant bugs in purely domestic criminal cases in order to protect national safety. And this was a very large step, even from the other aggressive and controversial actions. And so the government, starting in July 1959, started placing microphones, breaking in and placing microphones in known mob locales, and started listening in. And this famous quote from William Romer, "One microphone was worth 1,000 agents," because you put a microphone into where the mob is talking, and you can hear their plans, and they don't know that they're being listened to, and they reveal everything. So it was a part of this program that the FBI starts bugging my Uncle Tony Giacalone, who I referred to earlier, and Chucky's mom, Sylvia Pagano, who was also Giacalone's girlfriend, even though he was married. And in 1961, the government broke into Giacalone's office and placed a bug. 2 months later, the Supreme Court reiterates that this is illegal, and the government keeps doing it nonetheless. And then soon thereafter, they break in and they place a bug in Chucky's mom's home. Chucky's mom, as I alluded to earlier, was really the main go-between between Jimmy Hoffa and the mob, with whom she was very close. She was raised in the Kansas City organized crime family. She was extremely close to the Italian organized crime family. And she was the one that introduced Hoffa to the mob. That's another story. And she was the go-between, the main go-between between Jimmy Hoffa and the mob. So she was a point of serious interest for the government when they were trying to understand what was going on in the mob. And so they started bugging these two places. And for the next 3 years, let me get these numbers here. For the next 3 years, they based these bugs in Giacalone's office and Pagano's, Sylvia's apartment. They listened to everything. They swept up every conversation, and they transcribed them. And it wasn't just criminal activity, it was the full range of human conversation, talking about sex, family and health matters, political and religious opinions, gossip, everything. And all of these things were transcribed, and they were placed in a special set of files called the June files. And these are two pages of transcripts from thousands and thousands of pages of hundreds and hundreds of hours of illegal conversations in these two locations that I read in writing my book. And it's really as awful as it is. I mean, you may not be sympathetic to bugging the mob, but reading these transcripts and listening in to people's most intimate, private conversations, it was really just a remarkable and really disturbing experience to read these things. That said, I learned an enormous amount, as did the government at the time, about how the mob worked, the relationship between Hoffa and the mob, Sylvia's role, the fact that that Hoffa's wife was having an affair with a mobster during this period, all of this stuff, the fact that the Giacalone was using the drunken Hoffa's wife to steal from Hoffa, and all sorts of other things in these transcripts, these thousands and thousands of pages of transcripts. And these were during this illegal surveillance happened primarily during the years in which RFK, Bobby Kennedy, was Attorney General. During this period, the FBI conducted 842 wiretaps and installed 374 bugs, two of which I just mentioned. There's a debate about how much RFK knew about this. I'm convinced that he knew all about it. I can talk about that later if you want. But this was I just want to just say a few things about this. There was an arguable basis for warrantless wiretapping in the national security context. This was a debate that went on all the way up to the 70s and indeed into the 2000s, because the president, exercising his Article 2 power to arguably had the authority to do this, at least until there was, well, I'll just leave it at that, arguably had the power to do this. But extending it to domestic criminality, there was no justification for that. And so this was just blatantly illegal stuff. It flew in the face of those two Supreme Court decisions I just talked about, but it was happening in secret. And people in the Justice Department and the FBI knew about it. And it was going on a massive, massive scale. Again, I read many thousands of pages just on those two bugs. And there were, as I said, in those years, 374 of them. And this was, when the Church Committee wrote about this period in the 1970s, when all of this stuff came out, it focused on RFK's approval of a wiretap of Martin Luther King and how that wiretap was used to try to blackmail King or try to pressure him into killing himself, and a lot of the other things, illegal surveillance that happened in the context of civil rights. And the Church Committee said almost nothing about the illegalities involving the mob, because the mob is frankly much less sympathetic, but it was happening on a massive, massive wide scale. So now I'm going to turn to how this started to unwind, and it happened primarily because of two men in the middle of the 1960s. Senator Edward Long of Missouri, who was the author of the Freedom of Information Act and a libertarian, there was all sorts of stories in the early 60s about FBI bugging and surveillance, but none of it was confirmed, and it was kind of in the shadows. And it started to unravel in the mid-1960s. Long started pressing the government to reveal its practices, and this sparked panic inside the government. And then Edward Bennett Williams, the famous criminal lawyer, had a couple of cases where he pressed the government in court to reveal whether it had been using illegal wiretaps on his defendants, on his clients, and the government quickly settled the case rather than want to talk about that. So it was Bennett pushing this stuff that also caused the panic, that also gave it, greater headlines and greater prominence. I'm going to go a little bit fast through this because I'm getting short on time, but these two men were very consequential in kind of pushing this out from in the shadows into the public. By the time of 1965, the Justice Department was sufficiently panicked about the legality of this practice and the fact that it might come out that on LBJ's direction, LBJ was not a fan of wiretaps and electronic surveillance, believe it or not. I don't know if that surprises you. But he told Attorney General Katzenbach, who's pictured here, to end the practice against domestic criminals, including organized crime. And these are some senior FBI officials explaining Katzenbach's reasoning. The AG apparently feels that he is on solid ground in approving microphones and wiretaps in national security cases, but he is fearful of the long committee and attorneys such as Edward Bennett Williams with reference to the use of microphones in the organized crime field. And that is exactly right, because they were clearly unlawful under Supreme Court case law, even though they were happening on a massive scale. Fast forward to 1966, Thurgood Marshall is the Solicitor General of the United States. And for reasons I don't have time to get into here, basically Marshall, in a case called Black, involving a defendant named Black, confessed to the court that the FBI in 1963 had bugged the hotel room of this defendant and had overturned conversations with his attorney, and confessed error in the case. The Supreme Court then asked Marshall, okay, well, what's going on here? Give us a complete report about what the legal basis for this and who ordered it. Marshall said there's no specific statute or executive order that supported this surveillance, which was true. He dodged the question of who was responsible because there was a massive fight in public between Hoover and RFK about who had approved what and who knew what. But at that point, Marshall pledged to the court to disclose all the evidence of illegal electronic surveillance that gave the government any information which is arguably relevant to the litigation involved. So the government had to go through dozens and dozens and dozens and dozens of prosecutions to see if it had been infected with these illegal surveillances. And again, as I said, the year before, these surveillances stopped. This brings us back to Chucky's case. So Chucky, in the early 1960s, at the behest of a mid-level Detroit mob figure, had gone down to a customs. There had been a ship had sunk in the Detroit harbor. The remnants of the ship were in a warehouse. Chucky said he went there and bought certain things from the warehouse. The government accused him of stealing certain things from the warehouse, and the government convicted Chucky of this. And they had him dead to rights, it seems. But when it got to the Supreme Court, the tapes that I was just referring to, the home juice tapes, had the ones of Jack Loney's office had recorded Chucky talking about his forthcoming trial in this case. And Thurgood Marshall in United States versus O'Brien reveals this information to the court. And the court basically vacated the judgment and sent it back down and for a new trial. There was a dissent that said you should allow the district court to decide whether there should be a new trial or not, or whether this evidence was material. It's pretty clear at this point that the court was very suspicious of the government and was taking a pretty heavy hand in trying to cleanse all of these convictions of the taint. So Chucky was a side beneficiary of this extraordinary period of, well, he was subject to this massive illegal surveillance, but he was also the beneficiary of it being fixed in the middle of the 1960s, basically by Thurgood Marshall and Katzenbach and LBJ. And so this was, I'm going to end here. This is a picture of Chucky on the right just before he died. Chucky was not an educated man. He never had much schooling. He certainly didn't go to college. But he used to like to tell people that he graduated from Harvard in the late 1950s. And when I went to teach at Harvard, he was, we had made up by then. I'll talk about this briefly before I stop. And we grew close again near the end of his life. And he used to love to wear Harvard paraphernalia and claim that he was a graduate of that august institution. On the left is the book I wrote. And the story I just told you is one tiny sliver from the book. And I'll just say a few things in wrapping up. One, these events, me being in the Justice Department, being in the up to my knees, if not my neck, in an illegal surveillance program, stumbling across O'Brien versus United States and learning about the history of illegal government surveillance and learning that all these things Chucky told me growing up about Hoover and RFK and illegal surveillance and the government breaking the law in secret was true, was the event that led to a series of events of Chucky and I reconciling. And I won't tell that story here. I tell it in the book. And in the book the book is mostly about Chucky's life with Hoffa and my efforts to clear Chucky from the taint of the allegations against him in the Hoffa disappearance, which I believe are false, and I believe I show as best can be shown were false. I'll just say that story too was a story of Chucky being treated with abuse by the Justice Department and the FBI. Not all elements of the FBI, I might add. In the course of writing the book, I grew close to the FBI agents who were involved in the disappearance in Detroit and New Jersey, and these were absolutely upstanding, amazing FBI officials. But the FBI lied and misled and subjectively leaked, as did the DOJ, in efforts to get Chucky to talk. And there are a whole bunch of other examples of malfeasance during the Hoffa disappearance. Now, I want to be clear. Chucky was not an angel. He broke the law a lot. He didn't respect the law. He and I had basically opposite values about the rule of law. He had a completely different ethical worldview. But he did have legitimate complaints about what happened to him. And the last thing I'll say is just that this whole episode, thank God for me, brought Chucky and I closer. We grew very close again in the last 10 years of his life, just as we were when I was a teenager, when he was such an amazing father to me. And I will end the story there and take any questions you have.
Thanks. Thank you very much, Jack. It's a fascinating story, and you tell it so well in the book. I would encourage all of our audience to read your book, In Hoffa's Shadow. And there's so many more details that, in the book and the aftermath of the O'Brien decision, and then in your involvement, and digging further into this mystery of Jimmy Hoffa's disappearance. We have questions from the audience. I have a couple of my own I'd like to start with. And the first being, in the aftermath of the O'Brien case, and you were at a young age when this came out, I guess.
I was 5 years old. This is before I met Chucky.
Right. But in the telling of the story of the O'Brien, did you notice that if it how it impacted his life?
The O'Brien, the decision?
Yes.
So that's a great question. And until you asked me, we talked about this a little earlier, until you asked me this question, I had never thought about that question. And the answer is interesting. So at the time, this was a gift from heaven. Chucky thought he was on his way to jail for the first time in his life. He had skirted the law his whole life, literally skirted the law. He had been involved in trials. He had the RFK team that was the Get Hoffa squad that formed to put Hoffa away was also going after Chucky. And Chucky had always managed to, skirt jail through a variety of means. But this time the government got him. And it looked like he was going to jail for a while, not clear how long. And so when this decision came down, and it was kind of a gift to him that Thurgood Marshall confessed error about these secret tapes and that Chucky had been overheard, he was joyful about it because he was avoiding jail. Now, one counterfactual is, though, if he had gone to jail, he might not have gotten tied up in the Hoffa disappearance for a whole bunch of reasons. And the Hoffa disappearance destroyed his life. It destroyed the last 40 years of his life. And so it's very hard for me to run the counterfactuals, but at least soon after the decision, he was very happy about it.
Yeah. And the story behind it coming to the Supreme Court's attention and Thurgood Marshall's role in that, isn't a bit unusual for the Solicitor General to go to the court with these sorts of, in looking back at former cases?
Yes and no, mainly yes. I mean, the SG does occasionally quote unquote confess error unquote. This isn't when on occasions when the government decides that for something that's uncovered over the course of the case that it can no longer defend the conviction, it will go to court and confess error and explain why. What is remarkable about the Marshall episode is that there had been this internal decision in the Justice Department that this longstanding practice could no longer be justified. And so a year earlier, they had stopped it, but it was starting to come out. And so Marshall took this anticipatory step of confessing it in one case. And I skipped over this detail. But at that point, the Supreme Court said, well, tell us about this. What's going on here? And Marshall basically did a thorough investigation and told the court what it found in terms of the legality of the practice, at least the legal basis for the practice. And as I said, who had been involved in approving it. He was very vague about that. But then he made that pledge that I alluded to do a thorough investigation and in every case confess error where any of these convictions had possibly been tainted with these illegal bugs. And if I could, and wiretaps, and if I could just say one thing, and there's a whole nother story. So that's 1966, 1967. Over the next 10 years, there's a revolution in Fourth Amendment law and surveillance law. The Berger case, the Katz case about reasonable expectation of privacy, changing the nature of the Fourth Amendment and expanding its protections in many respects. Title III and authorized statutory wiretaps, the Foreign Intelligence Surveillance Act, all these things happen in the next 10 years, and there's a massive revolution in surveillance that puts it on a much firmer and somewhat constrained legal basis, all of which come back to these events. So these events kicked off another 10 years of revolution in Fourth Amendment law and surveillance law that really has been iterating ever since.
Another question I have, Jack. Thank you. It's very good perspective and historical perspective on it. Another question, and you didn't get into this, I know, because of time constraints, but your efforts with Chucky and going back to the FBI and DOJ to help clear his name, get him removed from the suspect list, and get clearance of his reputation in that realm. The concept of omerta played a huge role in challenge to you in that regard. I have an observation to make about that and your interactions with the FBI and DOJ as you really were reaching a positive conclusion toward the end of those efforts. But could you explain that concept of omerta and how that may have presented some challenges for you?
Sure. So let me just back up and I'll just give the 2-minute version of this. So when I set out to write this book, Chucky and I had made up, and I decided, and I became convinced through just, casual conversation with him and how much he revered and loved Hoffa, that he wasn't involved in the disappearance. This is before I got into the details. And let me just say 2 things about Chucky that presented a massive hurdle to figuring out what he knew and what the truth was from his perspective. One was Chucky was a famous liar. He was a pathological liar, and I use that term advisedly. And one of the things in all the FBI documents and all the interviews about Chucky is that he was constitutionally incapable of telling the truth. And I knew this as his son growing up with him because he was constitutionally incapable of telling the truth. The difference between truth and fantasy for him, he was always telling the truth that he wanted it to be, not as it was. That was one rather major hurdle since he was an important witness. And that was something I negotiated, and I explain all this in the book. And I got good at figuring out the truth from him. And the second hurdle was omerta, which, just to translate, is basically the idea that you don't talk about mob secrets. And Chucky really believed in this idea. he really, to the core of his being, he was not a made man. He couldn't be because he was half Irish and half Sicilian, but he was raised by, as he put it, the Italian side. And that's where his values were. And Giacalone instilled omerta in him. I talk about this in the book. And his mother instilled omerta with him. And he was just not supposed to talk about these things. And he never did. And yet, with me and talking about these things, we kept bumping up against this rather large hurdle to our conversations. And we found ways around it. And sometimes he told me things he didn't mean to or wasn't supposed to. And other times he just stopped talking. But that was another huge hurdle right until the very end in trying to tell the truth of what happened here. Now, obviously, I had many, many other sources, including tens of thousands of pages of documents, internal government documents, and the like, and interviewed every FBI agent who was involved in the case. But those were two rather large hurdles in my trying to figure out the truth here.
I want our audience to read your book, and I encourage them to do so. I don't want to spoil it entirely, but
I don't mind. It's fine.
But I was left at the very end with the feeling that not only was Chucky loyal to the code that they used by Omerta, but there was an element of that same sort of code within DOJ and FBI. That is, that they would not want to reveal something, although you know, it's, as you mentioned at the outset, there were very good agents there at the FBI, and then you witnessed Thurgood Marshall's initiative to disclose wrongdoing in the past to correct it going forward. So there is that element of, but there's also an element within of institutional protection.
Yes, I'm sorry. I understand your question now. I didn't understand it at first. Yes.
Yeah, I guess it's a long way to get to the question, but but the question is, did you have a sense of that at the end, that the desire for institutional protection about embarrassment of wrongdoing within the institution prevented an ultimate resolution in Chucky's case?
That's certainly my belief, and I lay it out in several chapters in the book. I'll just give the short version. I don't like to attribute bad faith to anyone, and so I'm not attributing bad faith to anyone. There's no doubt. I mean, I document the ways in which the FBI lied about Chucky based on their own internal documents and external statements, and based on a lot of interviews with a lot of people. There's no doubt that they said a lot of things about him in public that they knew to be false. There's no doubt that many people were convinced going back 20 years before I wrote the book inside the government that he had nothing to do with it. And there's a lot of evidence to that effect. And I did my very best to get them to admit that Chucky was not a suspect in the case. And basically they told me they were going to do it, and then in the end didn't. And all I can say is the FBI and the DOJ are not in the business of confessing error if they don't have to. And so they didn't. And it was very disappointing, even though they said they were going to, and they have their own story. But it was a form of omerta it's a different form of omerta. They don't publicly,
right,
in a way that brings discredit on them, even if it's legitimate discredit.
Right. Okay, questions from our audience. Are any of the movie portrayals of Hoffa and Chucky accurate? And I'll combine this with another one. Would you like to say anything about the movie The Irishman, which came out shortly after your book is published? I would make a plug for your paperback version of the book, because you have an additional appendix that addresses that very thing, the movie. The Irishman.
I'll just say this about The Irishman. I've written about this in great detail, and in other places I have a New York Times article, op-ed about it, and something in the New York Review of Books, and something on Lawfare. 3 pieces about The Irishman. The Irishman is fictional. Basically, what the author did was to put Sheeran in Chucky's role as his right-hand man. And so that movie is mostly fictional, and it portrays Chucky driving Hoffa. It portrays Chucky as a nimwit driving Hoffa to his death. But that's the standard story from 1975. The thing that was so hurtful to Chucky was that it puts Sheeran in the role of Chucky's role as Hoffa's right hand man. So that movie and that book are full of demonstrable errors and fabrications, as I explain in those sources. The other movies, there have been 4 Hoffa movies. Chucky has a role, not necessarily by name. Danny DeVito plays a role based on Chucky in the Jack Nicholson version of the Hoffa film, and DeVito is there portrayed as being involved in luring Hoffa to his death. All the Hoffa movies are fictional, as I must say, almost every account of what happened to Jimmy Hoffa. It's just fiction almost all the way down, as I try to portray in the book. It's all based on the original FBI theory in 1975. The government knows that the story is very, very different now. They have not revealed this. I'm confident of this because I've seen the documents and I've interviewed the FBI and U.S. attorneys, U.S. attorneys involved. But that's what I'll say about that. The movies are all historical movies are fictional, but the Hoffa ones are especially so.
Yep. Another question from the audience: did Chucky spend any time in jail subsequent to Hoffa's disappearance?
Yes, he did. When I was in high school, the government was very tough, as they tend to be on people that they're trying to get to talk about things. And they used everything in the book against him. They used the IRS to basically garnish all of his wages for a whole bunch of reasons. And they sent him to jail for 9 months for inflating the value of property on a bank loan application. So he spent 9 months which was as the judge said, a ridiculous prosecution. Please don't ever bring me another one like this again. But they were able to convict him, and it wasn't hard to do. He spent 9 months in jail when I was a junior in high school, and that's the only time he spent in jail.
And what was his career like after that? What's the follow-up?
He was ruined in the Teamsters Union for a whole bunch of reasons, and he was kicked out of the union in the 1980s when the government basically took over the union in the late 1980s, and they had a process whereby they kicked out anyone connected to the mob, which Chucky was. And so he was kicked out of the union in the late 1980s.
Last question. This is from someone whose father was a Teamster. They discussed Hoffa growing up. His theory was that the Hoffa case was never solved because all the people that were involved were in jail or dead, and therefore not a priority. Your thoughts about that? And if you'd rather not go in that direction.
I'm happy to tell you what I think. I mean, I can tell you that for up through about 2005, so that's 40 years.
Yeah.
There were FBI agents aggressively trying to solve the Hoffa case. I lay this all out in the book, and they think they know now who at least picked Hoffa up. They've got some indirect circumstantial evidence that they think they know who picked up Hoffa. They don't know what happened to Hoffa's body, but they aggressively pursued the case up through at least 2005. I don't think they pursued it very aggressively in the last 20 years. But, and at this point, almost everybody who's dead. Chucky passed away a couple of years ago. I think there are 1 or 2 of the kind of outside suspects who are still alive, but I don't believe it's ever going to be solved in a definitive way.
Thank you very much, Jack, for joining us today. We appreciate our audience's participation as well. And I think we could have gone for another hour.
Well, there's a lot more to say. I just gave you a sliver of it.
You did, and you did a fine job of that, condensing what is, I said at the outset, a compelling read in your book. And again, encourage all to read it. We have 2 lectures remaining in this series. Siobhan Barco will speak virtually on April 22nd on Myra Bradwell. and Ken Mack will be speaking on May 21st on Lloyd Gaines and the aftermath of Supreme Court cases in which they were plaintiffs. Registration is open for both events on our website at www.supremecourthistory.org. And finally, a survey will go out later this afternoon to everyone who's registered in advance. Your feedback is critical to making these programs as informative and as engaging as possible. When we encourage your participation and giving us feedback. Thank you all for joining us today. Thank you so much, Jack Goldsmith, for your outstanding work and presentation. And we hope to see you again. We are adjourned.
Jim, thank you, everybody.
Thank you.
Bye-bye.